Hello friends, a very important decision has come from the Bombay High Court in the matter of Skytech Rolling Mills Private Limited versus Joint Commissioner of State Tax. This judgment was delivered by the Bombay High Court in the matter of Section 83 of the CGST law. Before understanding this decision, let's try to understand what exactly is Section 83 of the CGST law talk about. Section 83 of the CGST law gives power to the Commissioner to attach properties, including bank accounts, if any proceedings under Chapter 12, 14, and 15 of the CGST law are initiated against a taxable person, and if the Commissioner is of the opinion that it is necessary to protect the interest of revenue, the Commissioner may, by an order in writing, attach properties including bank accounts of a taxable person. Subsection 2 says that this provisional attachment will cease to have effect after an elapse of 1 year from the date of attachment. So the maximum period that this can attach properties is 1 year. And no money can be appropriated under this section because there is no demand. There is no confirmed demand. Only some proceedings have been taken under Chapter 12, 14 or 15. Let's try to understand what are the proceedings that are likely to be taken against a taxable person under Chapter 12, 14 and 15. Chapter 12 talks about assessment. So scrutiny assessment of unregistered persons, assessment of non-filers, etc. come under this chapter. Chapter 14 talks about inspection, search, seizure, arrest, etc. And chapter 15 talks about demands and recovery under section 73, 74, 74A, etc. So it is necessary that the department should have initiated some proceedings under any of these chapters against the taxable person. And then if the Commissioner is of the opinion that it is necessary to protect the interest of revenue, he may, by an order in writing, attach properties including bank accounts of the taxable person. And this is a very strong provision because principles of natural justice are not at all followed. This is almost like a surgical strike. The taxable person will know about the attachment only after he gets an attachment order. So to that extent, this is a very strong provision. And the department usually goes after bank accounts. They try to attach bank accounts in most of the cases because once they attach bank accounts, they can appropriate money anytime they want if the proceedings ultimately culminate in a demand. So once a bank account is attached, the working capital management of the business will have problems. So unless the taxable person is able to raise money from outside immediately, he will have severe problems in managing his business on a day-to-day basis. And to that extent, this is not a very good decision or a very good measure as far as ease of doing business is concerned. And this section has a corresponding rule, which is Rule 159. What does Rule 159 talk about? Rule 159 says that this order of provisional attachment has to be served in form DRC 22. And this DRC 22 order should specify the asset or property that is being attached, and it should be served on the taxable person and also on the person who is expected to ensure that this property is not transferred after this attachment, and also that there are no further encumbrances are created on the property. To take an example, if a bank account is attached, an order will also be served on the bank manager. If a vehicle is attached, the regional transport officer will get an intimation in DRC 22. So he should prevent further transfer of this asset and also prevent any further encumbrances on this asset. Similarly, land registration authorities, collectors, land revenue officers, etc. will be served this DRC 22. So it will be served on the person who has to ensure that there is no transfer of this attached property and no further encumbrances are made on this property. And this section gives power to the commissioner to attach even perishable commodities. If a perishable commodity is attached, it is possible for the taxable person to go and release this property by paying the required amount of money. Otherwise, commissioner is also empowered to sell this to third parties also. And since no advance intimation is given, the taxable person will understand about this attachment only after he gets DRC 22 order. So after getting this order, if he wants to object to this attachment, he may give his objections in DRC 22A to the commissioner, and commissioner should grant a hearing, consider the objections and pass order. And we know what this order will be like, because the commissioner has already decided to attach the property, has already attached the property, and what use will be there by our objections to the commissioner after the attachment has been done. Generally, it is of no use. Anyway, there is a procedure for us to give objections, and the commissioner should consider this and pass an order. And if the commissioner wants to release this attachment, he has to pass the order in DRC 23. So these are the rules as far as this section 83 is concerned. And now what happened in Skytech Rolling Mills Private Limited? In the case of Skytech Rolling Mills Private Limited, the commissioner attached their cash credit account with the ICICI Bank. Aggrieved by this decision, they went to the Bombay High Court and filed a writ petition. And they pleaded that, "My lord, my cash credit account has been attached by the commissioner under section 83. This attachment is illegal, arbitrary, and improper without jurisdiction, because section 83 gives the power to the commissioner to attach properties including bank accounts. So if a bank account needs to be attached, it has to be a property of the taxable person. It cannot be a liability of the taxable person. And in my case, my cash credit account is a liability. It's not a property. It comes on my liability side of the balance sheet. So the department does not have power to attach liabilities or bank accounts which have liabilities, which have credit balances. If the department wants to attach a bank account, it has to have debit balance. It should appear on the asset side of the balance sheet. And in my case, this is a liability, and this attachment is without jurisdiction, illegal and arbitrary. So we plead that this order be set aside. The High Court heard both the parties, went through the section and said, it's true. This section says you can attach properties including bank accounts. So even if you are attaching a bank account, it has to be a property of the taxable person. It cannot be a liability. So how come you attached a liability invoking this section 83? It is illegal, arbitrary, and without jurisdiction, and we are setting aside this attachment. So this decision is a very, very important decision for taxable persons whose accounts are attached by the commissioner invoking provisions of section 83, especially if they attach cash credit accounts, etc. And it is reasonable to assume that the department is attaching cash credit accounts, overdraft accounts, etc. because no businessman will have huge amounts of money lying idle in his bank account. They would be heavily borrowing money from banks to meet their working capital requirements. So it is logical to assume that the department is regularly attaching cash credit accounts, overdraft accounts, etc. So if your cash credit account, overdraft account, etc. are attached by the department invoking provisions of section 83, now you can go straight away to the High Court with a writ petition, and definitely you will get this order set aside. So to that extent, this is a very big relief to taxpayers who find their cash credit account, etc. attached under the provisions of section 83. Thank you so much for the listening.